001120. This is Jeanette Dorsey versus Capital Metropolitan Transportation Authority, MV Transportation, Inc. Here in a motion for summary judgment. Mr. Brown and Ms. Allison. Who else?
I think that's all, Your Honor.
Okay, very good. So tell me, do you want a record in this case?
Yes, please.
You do, on a summary judgment. A little unusual. I mean, we'll obviously, if you want a record, we'll let you have one, but they typically are not necessary for summary judgment. Okay, it's just more wear and tear on my court reporter. So try not to have that. Keep that in mind for future make Happy Judge Day. Okay, all right, very good. So we are now on the record in GN 22-001120. Jeanette Dorsey versus Capital Metropolitan Transportation Authority, MV Transportation, Inc. We're hearing a motion for summary judgment. Let me first have announcements by the movement. Who is the defendant here?
Kristen Allison on behalf of the defendants.
All right, both defendants, Ms. Allison?
Yes, Your Honor.
All right, and who's here on behalf of the plaintiff?
Dustin Brown here, Your Honor.
All right, very good. All right, so we're hearing a summary judgment. I believe there's both a traditional one and a no evidence one. Ms. Allison, you may proceed.
Your Honor, this is a case regarding a personal injury that plaintiff alleges she sustained back in April of 2020 when a bus driver employed by MV Transportation allegedly closed the door on her left leg while she was entering the bus. We're moving on summary judgment as to the medical causation of her injuries. There's no evidence that any of anything in this accident, there's no expert testimony or medical records that indicate this closing of the door on her left leg caused all of these problems to her toenails, her back, her neck, her left and right ankles, both her shoulders or her uterus. So I'll start with that first, and then I guess we can take this step by step because this is kind of a multifaceted motion.
Okay.
May I interject?
Why?
Well, some of these facets I'm not contesting.
All right, tell me what you're not contesting.
I think that the negligent hiring, retention, and supervision, we have not responded to, and we would not contest that aspect.
Okay, so negligent hiring, supervision, and what else?
Training and retention.
Training and retention. Okay, very good. So summary judgment is granted as to negligent hiring, negligent training, negligent supervision, and negligent retention. Okay.
I believe paragraph E, the motion for Capital Metro not having a legal duty, MVT or MV Transportation does not bring that up. So as regards to Capital Metro, we would not have an objection to that, assuming that the defense is in agreement that MVT is not making that same contention. But
I guess I'm struggling a little bit to understand. You mean, are we still back on the negligent hiring, training?
No, Your Honor.
On something else. Okay.
If I may, MVT is not disputing that they owned the bus or employed the defendant. So
Capital Metro is, right?
Correct.
Okay, so what he's saying is that actually Capital Metro is right in terms of their no evidence summary judgment. There is no evidence that they are the correct party in terms of this case. Is that right, Mr. Brown?
Yes, Your Honor. As I read the motion, Capital Metro is the only one claiming that.
Right. Okay, so you don't contest that. Is that right, sir?
That's correct.
Okay, all right. So summary judgment then is granted as to Capital Metro Transportation Authority. So it seems like what's left, and tell me if I'm wrong, is it just simple negligence on MV Transportation, Inc.?
I believe so.
Okay, all right. So we're talking about a negligence claim on MV Transportation, Inc. Was there any claim for gross negligence, Mr. Brown?
No, Your Honor.
Okay, very good. All right, so we've cut it down. Thank you. That was a interruption well worth its while. So now we're pretty focused. We're talking about simple negligence pertaining to MV transportation. The rest of the issues, summary judgment is granted. Ms. Allison, I want you to put that in your order to me, regardless of what I rule on the other issues today. I will need an order on that. Okay.
Yes,
So make
Judge.
sure you get everything in there because it's kind of a lot. So, all right, now that we've kind of cleared the deck a little bit on that, thank you for that, Mr. Brown. Let's talk about defendant's motion for the remaining defendant's motion, MV transportation regarding to causation pertaining to the medical damages allegedly suffered by plaintiff. Go ahead.
So specifically, Your Honor, we're disputing causation, the causation element of negligence. First off, plaintiff has served and filed 18001 affidavits, and she's attached them to her response. But as you're aware, 18001 affidavits are not medical evidence. And as to causation, there's no expert testimony within the medical records themselves. None of these doctors actually say that the injuries that she's complaining of or symptoms she's complaining of were caused by this accident.
Okay.
She has the records do indicate pre-existing conditions as to osteoarthritis, abnormal pap smears, and prescriptions to her lower region. And there are no records at all indicating that this accident caused any issues to her uterus or any dislodgement of her vaginal mesh. None of the records indicate that the surgery that she did have was necessitated by this accident, just that she required surgery.
Okay. All right, very good. Mr. Brown, let me hear from you.
Yes, Your Honor. To give a little bit of a description of why I think this motion is filed is that the client, or my client, Ms. Dorsey, testified in her deposition about a couple things she thought was related. I'm trying to. All right. And reading from the defendant's motion, injuries to her toenail, back, neck, ankle, both shoulders, and the dislodging of her vaginal mesh. As far as the toenail and the vaginal mesh, I can, as with the other aspects, that I can get on board with that. We don't have any evidence that the vaginal mesh was affected by this. As far as the toenail, I don't have any experts saying that her toenail fell off is because of this either. But in regards to the other issues, I think that what the defendant has done is kind of lumped all of the injuries together and said there's no evidence here, and that's just not the case. I've attached several medical records that detail the injuries and connecting them to this incident on the bus when the door closed on her ankle.
Yeah.
The defendant's motion states that 18001 affidavits were not filed, but it seems like here today they said that they have been filed, and they have been filed in the case. And in regards to these affidavits that I've attached and uploaded, there's clear indication that the client, or Ms. Dorsey, that the door shut on her leg, and then she went to the doctors about it and complained to them about it. I believe the expert might be needed for maybe the toenail falling off and the vaginal mesh issue, but I don't think we need to retain experts about a door closing on somebody's leg and them falling down and experiencing pain from that incident. So my objection would be that an expert is not required. There's evidence here, and more than a scintilla, and definitely in the 4 affidavits and medical records that I've attached that clearly discuss a door shutting on her leg and her experiencing pain to several parts of her body. I mean, not just the ankle, but I believe she also complained of the neck, back, and shoulders as well when seeing those providers.
Okay, so you've released the claims related to the vaginal mesh or
Yes,
uterine mesh. Where's the mesh, Miss Allison? What's the mesh? Help me.
In her uterus?
Yeah, uterine mesh. Okay, uterine mesh. And you've released the claim as to toenail and
yes,
injured toenail. Okay, but you are retaining the claim as to neck and back? What's the one that's retained?
yes, and her ankle and shoulders.
Okay, neck.
So she fell as a result of this door shutting on her foot,
Mhm.
and then complained of pain and injury. Later,
Right.
even having an ankle surgery.
Oh my goodness. Okay. All right, Miss Allison, let me hear from you.
Your Honor, Mr. Brown's right. 1801 updates were filed. That was a mistake on her part.
Okay.
Within the medical records, though, none of these providers say that these injuries were caused by this accident. As I said earlier, she's got a pre-existing history regarding osteoarthritis and other issues, but also the fact that none of her doctors say that this surgery was caused or necessitated by this accident. She had a subsequent fall. She actually has a history of multiple falls in multiple places and multiple lawsuits related to those falls.
Right.
So
So this is all great stuff, and I'm not disagreeing with you. I mean, ultimately, the jury may find this lady is, because what he's arguing here is eggshell. Eggshell. You take him as you find him. She's an eggshell. Okay, she's got osteoarthritis. So what? This door closed on her ankle. She's an eggshell plaintiff. You take that plaintiff as you find him, Ms. Allison. What you're arguing, Ms. Allison, is that she's not vexatious, that she's, I'm sorry, help me here, that she's is involved in secondary gain. She's got other lawsuits, all day long. That to me is sounding fact issue-y, but it's a lot more narrow. Like we've narrowed it down from all these other claims and two defendants to one defendant, and basically neck, back, shoulder, osteo type injuries. I am not sure. I'm not seeing my way to a summary judgment on that piece yet. I just don't see it. So here's what I'm going to do. I'm going to grant summary judgment as to all the claims released by plaintiff, and I think that is all claims as to the Capital Metropolitan Transportation Authority. Those are gone. As to the MV transportation, plaintiff has voluntarily released all claims as to negligent hiring, supervision, training, and retention. The only claim is simple negligence related to that door closing. All right. In terms of medical claims, plaintiff has released all claims related to any type of uterine mesh or surgery that's necessitated by that. I have no idea what's happened to this woman, but any type of surgery related to her uterus and her vaginal area, he's released those, and he's released the injured toenail. What's left then is neck, back, ankle, and shoulder. Now, I don't think, I mean, that seems like you'd fall and you might hurt those parts. And we do see that. So I think that is, and what you're saying is, look, Judge, she's got osteoarthritis. I'm not disagreeing. She may well have that. But Mr. Brown's going to say, okay, she's an eggshell. Ms. Allison's going to say, but yeah, but look, Judge, she's got secondary gain here. That may well be. Those are arguments for the jury. So I'm going to deny summary judgment as to that piece of it. So Ms. Allison, I want you to get an order drafted that records all of that. You're going to give Mr. Dustin Brown, send it to him and give him about 8 hours to review it at least, because he's got other stuff. But if you don't hear back from him, then that's done. You have done all you need to do. And then you needed to get it to me. So it's now about 2:40 in the afternoon. You're going to hang up this call and start on that order while it's still fresh in your mind, and you're going to get it to him. So I'm expecting you to get it back to me by 5 o'clock tomorrow. Okay? And if you don't hear back from Mr. Brown signing us to form, I'll get what's happened. Just show me that you emailed him, and then I'll sign off. That's going to leave you some pretty narrow issues for trial. But we have trials like that here in Travis County. So that's where y'all are going with it. Now, it's an older case. Ms. Allison, do you have a docket control order in place?
We did, we were originally set in 2024. We didn't get reached. Let me see if we have been reset.
No, you all were set for November and there's nothing else is set, so we need to reset you all. So what I'm going to do then as part of this list of things to do is I want you to also get a trial setting, and I want notice of that by 5 o'clock tomorrow as well. Okay, that you all will set your trial. Now, on a case this old, I mean, I kind of wish I could just grant summary judgment and get rid of it because I don't think there's a lot of interest in this case right now. I wish I could do it, but I can't do it because we just aren't quite there. But if you all can figure out some way to get this resolved, of course, you don't have to set a trial. But let me just tell you, when trial settings roll around in Travis County, you know, as they say, Katie barred the door. You almost always get reached because we've got 12 judges here and we've got a central docket. So you're going to trial. If you're in my court, you're going to get a telephone call from me on Thursday asking you all kinds of unpleasant questions. So do take a look at, before you go to trial, take a look at the standing order, right, on what we expect before trial. This talks about motion in limines, it talks about exchange of exhibits, it talks about witnesses. And you know, you need to be familiar with that, folks. But this is all a heck of a lot for a 2022 case. So Mr. Brown, Ms. Allison, y'all really think, do you really want Travis County time on? Do you really want a judge like me breathing down your neck on this? You might not.
Your Honor, we have begun settlement negotiations.
Very good. Well, I'm just telling you, because it's going to get real fast, especially because I'm ordering you before you get back with me at 5 o'clock tomorrow to make sure that I have notice of a fat, happy trial setting. And if you're not, then I'm going to drag you back in again to show cause. Why not? Okay. So sorry, I'm just trying to get tough with y'all because realistically, a 2022 case with these types of facts, it's not, you don't want it hanging around. Okay. All right. So Ms. Allison, do you understand all the things you're drafting and doing?
Yes, Your Honor, I've got an order to be sent over to Dustin today.
Yes.
And conferring with him on a trial setting to request a neutrality.
Right. That's right. And then you're also, once you do that, you're going to pull up the Travis County standing order and you're going to review, you and Mr. Brown are going to review, maybe even together review all the rules on this and restart those settlement negotiations. Okay. I just want you to look at the standing order on pretrial for Travis County because it's no fun when you show up without that. It's just unpleasant for everybody. Okay. All right. Very good. That's all we have today on this case. Thank you all for your time and you may be excused. Okay.
Thank you.
All right. Thank you. Bye now. 05359. This is Ryan Sullivan versus Two Greer Brothers LLC. Jeff Greer and Guardian Custom Builders. Who do we have here on this case? Mr. Brian Buster. Okay, who else is here?
Matt Williams is here for the movement.
All right, so we have Matt Williams here on behalf of the movement, and the movement here is the Two Greer Brothers LLC, sir?
Yes, Your Honor.
All right, very good. And Mr. Brian Buster, who are you here on behalf of, sir?
I am here on behalf of the plaintiff and the respondent, Ryan Sullivan. And I'm actually one courthouse down from you because I came in person before realizing it was on Zoom. And so I'm in the ready room next door.
I'm glad I heard there was somebody out there and I just couldn't break away to go look and see who it was. I'm glad we got you situated.
That would have been me.
That's just no fun. That is no fun when that type of thing happens. I already had one
at 9 a.m. here this morning. So, you know, I'm making a day of it.
Making a day of it here at the courthouse. Well, that's good. Well, I'm glad that you're here with us. Thank you for reaching out and finding that place to be for the hearing. That's all very good. Okay, so with that then,
can Mr. Buster, are you able to turn up your audio just a little bit?
Sure, let me try.
Or just get a little bit closer? Yeah.
Do you all want this on the record?
Yes, sure.
Okay, all right. On the record then. Okay.
And is that better, Della?
That's a little better, yes. Thank you.
All right, very good. So with that, Mr. Williams, you may proceed.
Okay, and we announced for 30 minutes, and I actually don't think it's going to take near that long to do this. This is a pretty simple matter. This is a 91A motion filed by Two Greer Brothers LLC. The plaintiffs filed a lawsuit against the defendant seeking damages for breach of contract. And one significant problem with that is the fact that the movement was not a seller of the property and
Okay,
was not a party to the contract.
okay,
And so we sought a 91A motion. I think I probably should point out that an amendment was filed on Monday, removing this cause of action. Problem is, it wasn't timely. So under 91A, if you file an amendment removing the offensive cause of action at least 3 days before the hearing, then things happen under 91A. However, this was not timely. It was filed on Monday, which would be day 0. Today's
Okay.
day 2. If the hearing was on the 6th, then we'd be in a different position. But under 91A, the motion goes forward as if the amendment wasn't filed. So, and I can get into those subsection 91A if you need me to. But the bottom line is the cause of action has been amended. But the
Okay.
court's not technically supposed to consider the fact that the amendment was filed because it wasn't timely.
right,
And so really we're just here. I've sought attorney's fees, and I've got an affidavit supporting attorney's fees attached to the motion. We're seeking fees of $2,859.50. And I have a proposed order granting the motion, dismissing this cause of action for breach of contract against the defendant and awarding attorney's fees, and it's in box.
okay.
And-
All right, very good. Anything else, Mr. Williams?
Unless you have any questions or anything specific, I can discuss I can discuss 91A or computation of time under Rule 4. I can talk about any of the other aspects of the motion, but because it doesn't look like we're really fighting on the merits so much, because I think the amendment, I think we can take that, even if we're not considering it, we can take that as an acknowledgement that it's not a good cause of action. Unless you have any other questions, I think we just pass it to Brian.
Okay, very good. Thank you. Mr. Buster, let me hear from you.
Yes, Your Honor, and I understand computation of time and everything. The third day was on a Sunday. We filed on a Monday. I'm not debating that. What I would like to bring to the court's attention, though, is that Mr. Williams, in violation of Rule 91A.6, attaches an exhibit to his 91A motion to prove his point that this person was not party to the contract. And under 91A, you're only supposed to rely on the face of the pleadings to show whether or not it has no basis in law or fact. Now, I've got a case that I'd point the court to. It's titled Southwest Airlines Pilots Association v. Boeing Co. That's 2022 Tex App Lexus 8186 is the citation. Okay. And it stands for the proposition that the determination of whether there is a legal or factual basis is made from the face of the petition, not other parties' pleadings, the other party here being the movement.
Okay.
The rule requires determination of baselessness be made from the allegations of the cause of action and the facts pleaded in the cause of action, not from documents extraneous to the petition and presented by other parties, again, here, the movement. And so, his 91A motion brings up the fact that he's got a valid defense of merger doctrine, and the case that I've cited also brings up the fact in that case there was a res judicata defense and they attached exhibits to prove up their res judicata defense. But the court said that, that's a summary judgment. That's a summary judgment on the affirmative defense. And here that would be a summary judgment on his affirmative defense of merger. And therefore this is not proper for 91A based on the fact that he has to use evidence attached to his motion in order to, I guess, prove up his motion. Now, again, the fact is we've amended the petition. He's got the relief he's seeking. He could have reached out and pulled it down, but we're here. So
Right.
We would ask the court to deny the motion based on the fact that it's violative of Rule 91A.6. And then at the same time, he's already getting the relief that he's seeking outside of his attorney's fees.
Right, and you don't get hit with the $2,800 in fees. All right, Mr. Williams, I have to admit, I'm a lot more familiar with what happens on a plea of the jurisdiction when evidence is attached, which you can on a plea. you can attach evidence to show jurisdiction. So help me with what's going on here.
Well, so first of all, we attached in compliance with 91A, done a number of these. We attached his pleading for the convenience of the court, and then we identified the paragraphs that were the offending paragraphs where they make no allegations supporting the fact that my client would be liable for breach of contract. They do not assert and cannot assert that my client was a party to the contract. They do not assert and cannot assert that my client was the grantor of the deed to his client. And so on the face of his we point out that the face of his document, it does not support the cause of action for breach of contract against my client in law or fact. And the only evidence that we're actually asking the court to rely on is the face of the pleading itself and my affidavit, which is allowed under the rule.
Okay.
And my affidavit is attached.
Mr. Buster?
Yes, and I apologize for jumping the gun there, Your Honor.
Mhm.
Yeah, but I mean, the problem is that he doesn't just rely on that. He's got Exhibit 2 attached to his motion, which says,
I agree with Mr. Buster on this one. I'm going to deny the motion, but it seems like that the problem is already fixed because Mr. Buster has non-suited. So the motion is denied based on that case that Mr. Buster was familiarizing us with. Gentlemen, thank you both for the thoughtful arguments. Mr. Buster, please get us an order, and I need that order over here by, can you get to me by noon tomorrow?
Your Honor, I've got one printed out and I can walk it directly to your court right now since I'm
Okay.
here.
Yeah, if someone can let you back here is the problem. So we're all in court right now, so I can't send someone out because we're having a kind of I'm here. Some of us are here, but we're not all here. So if you can get it back, that's great. If you can get it even to Judge Mozzie's court, they might be in there, then I can go pick it up. But we'll sign it and get it filed, okay?
Okay, thank you very much, Your Honor. Maybe.
All right, thank you all.
Thank
You
you,
may
Honor.
be excused. Goodbye. This is Catherine, David, and Haley Anderson versus Austin Bell LLC, Austin Bergstrom Landhost Enterprises, Inc., Boykin Management Company, LLC, Boykin Prospera, LLC, Hilton Franchise Holding, LLC, and Brianna Celeste Viejo. We're here on a special appearance. May I, do you all need a court reporter?
Yes, Your Honor.
All right. Okay, I'm going to ask you to announce whom you represent and what your name is so we can get that on the record. Please proceed.
Your Honor, my name is Gregory Duboff. I'm here along with my colleague Ryan Frankel from McGuire Woods, especially appearing on behalf of one of the defendants, Hilton Franchise Holding, LLC. Yep. Thank you.
Right. Thank you. Who else is here?
Mr. Nunez, I can't hear your audio. This is the court reporter.
We can't hear you, Mr. Nunez. I see you've taken your microphone off and put it back on again, but it is not working.
Good morning,
Oh,
Your
now I hear you. Now I hear you. Yay. Okay,
I apologize. Good afternoon, Your Honor. My name is Stephen Nunez, and I represent plaintiffs in this matter.
Mr. Nunez for plaintiffs. Okay, who else is here?
Your Honor, my name is Brooke Swilley. I represent Boykin Prospera LLC and Boykin Management Company LLC.
Okay. Who else is here?
Your Honor, LaRonda Barnett is here. She's a client representative from Hilton Franchise Holding, LLC.
Okay, very good. All right. Who is the movement in this case, Mr. DeBuff? Is that you?
That is us, Your Honor.
All right, please proceed.
Sure. Thank you, Your Honor. And Your Honor, just a little bit of housekeeping, just full disclosure. We had filed my pro hoc motion on February 18th, and we called the clerk a little bit later. They said they had it. They just said they were very backed up. And so rather than keep pestering them, we just said, okay, but it's been filed. It was unopposed, Your Honor, but with the court's leave, I'd appreciate the opportunity to present the argument today.
All right, motion for leave is granted. I do want you to submit that order directly to me with whatever order I make in this case that I can sign it, okay?
Sure thing, Your Honor.
And you'll do that by sending, you have a pen and a piece of paper. You'll do that by sending it to 455.submission@traviscountytx.gov. Again, 455 455.submission@traviscountytx.gov, 455.submission@traviscountytx.gov. In the subject line, you'll write HO, which means hearing order, the cause number, and today's date. And I want whatever order I make in this plus your ProHawk so I can really get it signed. Has someone else already signed it? Because the clerk, that doesn't make any sense to me. Where did you send it?
Unfortunately, I've told you everything that I know, Your Honor,
Yeah,
but
no,
we filed
send it to me, because we don't file in Travis County. We don't file orders to be signed with the clerk. They've got to go to a court on submission. And if you
Your Honor.
didn't do that, then that's a problem. Yes?
Your Honor, I'm sorry. I can jump in as I was the associate who took care of that,
Okay.
Mr. Duboff's ProHawk. Per the Travis County local rules, we emailed the submission, submission docket that I read on the local rules.
Okay.
We did not file the proposed order. I have your instructions that
Which court is this? Which court is this file? Did you send it to?
It very well, I believe it was the 200th, which is where this was assigned. I realize we have a rolling docket in Travis County.
It's not this complicated. That's all I need to know. 200th tells me it's with Judge Mangrum, and I'll just call her and tell her I've asked y'all to send it to me. That's all. It's not the mistake here is it's not the clerk that holds it. It would be Judge Mangrum's court. So if you get it to me, Mr. DeBuff or Mr. Franklin, I don't care whom, I'll sign it, but I'll just let Judge Mangrum know that we've got it and we're getting it signed. Okay.
Excellent, Your Honor.
All right. Very good.
Thank you.
Thank you. All right. Mr. DeBuff, you may proceed. And if you're not on, just make sure to mute yourself so we get a good audio. All right, Mr. DeBuff, please go ahead.
Thank you, Your Honor. So Hilton Franchise Holding LLC is especially appearing here and challenging personal jurisdiction under Rule 120A. Just very basic terms, Your Honor, the facts alleged in plaintiff's petition are that the decedent Joshua Anderson was staying at the Hilton Austin Airport Hotel on November 2nd, 2023, and that he consumed alcohol and drugs and engaged in other activities and then died based on the drugs that he consumed. They allege that a bartender working at the hotel overserved Mr. Anderson with alcohol and also helped him procure the drug that ultimately caused his death. We are challenging personal jurisdiction here, Your Honor, because Hilton Franchise Holding does not own the hotel, does not operate the hotel, and does not employ anyone at the hotel. Its connection with the hotel is through a franchise agreement it signed in 2017 with the hotel's owner, Austin Bergstrom Landhost Enterprises, and then that, which is also a defendant in the case, and then Austin Bergstrom or Able delegated its responsibilities for day-to-day operation of the hotel to defendant Boykin Prospera.
Right.
So sort of before getting to the merits, Your Honor, the plaintiffs have made an argument saying that we waived our ability to challenge personal jurisdiction here, and they raised two arguments. The first one is that they say the conduct of other entities that are former defendants in the case, that somehow through those entities' conduct, we, Hilton Franchise Holding LLC, should be found to have waived our special appearance. They don't cite any precedent at all for that notion, Your Honor. It just violates basic principles of corporate separateness. And as Texas precedent makes clear, the personal jurisdiction is defendant specific, and the court has to analyze the conduct of each defendant individually in order to determine if there's personal jurisdiction. So that's the first waiver argument, Your Honor. They also argue that Hilton Franchise Holding waived our challenge to personal jurisdiction because I appeared at and participated in two depositions that were taken in January, if I'm not mistaken, of this year. So in very basic terms, Your Honor, Rule 120A itself says that even if I had been the one that subpoenaed a witness, if I had been the one that noticed the deposition, that wouldn't be enough to waive it, Rule 120. But I didn't even do any of those things. And I guess just even more to the point, Your Honor, we had just been named as a defendant in the case. The parties all informed me that they had spent a lot of time trying to get these depositions on the calendar, and they really didn't want to have to push those out, given that there was a new defendant involved. And so we agreed that that's fine. Let's go forward with the depositions. And they're not mentioned in plaintiff's response. At the beginning of each deposition, I, really belt and suspended it and said, hey, I'm here, but we're specially appearing. We are going to challenge personal jurisdiction, and plaintiff's counsel at that time, didn't say a peep in opposition to that or saying that was improper or anything of the kind, Your Honor. Those are the waiver arguments, and we don't think there's any basis to find that we waived this challenge. Moving on to the merits of personal jurisdiction, Your Honor, there's general personal jurisdiction and specific personal jurisdiction. We weren't sure from the petition what they were going with, so we made arguments against both of those, and I take from plaintiff's response that they are not, that they're conceding that Hilton Franchise Holding LLC is not subject to general personal jurisdiction in Texas, as we are neither headquartered here nor incorporated under the laws of the state of Texas. And then under specific jurisdiction, Your Honor, the standard that the Texas Supreme Court has announced over and over again is that there must be a, quote, substantial connection between the plaintiff's cause of action, the operative facts of the litigation, and the defendant's contacts with the forum. So the phrase is substantial connection. Other cases say that the claim must directly arise out of those contacts. The claim must be principally concerned with those contacts, and none of those are met here, Your Honor. It's plaintiff's burden to establish that personal jurisdiction exists. If the allegations in the petition are sufficient to make out a prima facie case on that point, then the defendant then can present evidence, which we've done. We've submitted 4 affidavits and the franchise agreement in this case. So presenting evidence that contradicts the plaintiff's factual allegations, which is exactly what we've done here.
Okay.
On this substantial connection piece, Your Honor, we think this is just a threshold issue and could make it very simple for the court. Plaintiffs don't dispute that the standard is substantial connection, but they also don't claim in their response that they've met that standard. So I think we agree that the standard is substantial connection, but they never say there is a substantial connection. They use other terms that are sort of, in the orbit of personal jurisdiction, like they say we had minimum contacts with Texas. They say that we personally availed ourselves of doing business in Texas. But the Texas Supreme Court has made very clear that when you're talking about specific personal jurisdiction, neither of those is enough. Just having minimum contacts with the state aren't enough, because that's not a substantial connection with the operative facts of this litigation. And the court's been very clear that purposeful availment, and this is a quote from the TV Azteca case from the Texas Supreme Court in 2016, quote, purposeful availment has no jurisdictional relevance unless there is a substantial connection between those contacts and the operative facts of the litigation. So we think based on that fact alone, Your Honor, they don't even contend that they've met the relevant standard. And so we think the special appearance should be granted on that basis. Getting a little bit deeper into the merits, I think what we agree on, Your Honor, this is one of those issues where obviously personal jurisdiction can arise in a number of different cases. So you have the general principles, and I'll talk about those in a moment, but you also have, well, how does personal jurisdiction work in the context of franchise relationships? And then there's a whole body of cases that talk about, in this specific context. So,
right.
And so I think you can kind of come at it either way, Your Honor. Obviously those two lines of cases are not in tension, but obviously one is more specific than the others in terms of franchising. I think what we agree on, Your Honor, we laid this out and provided several cases for authority in our motion, and plaintiffs don't contest this in their response, that for a garden variety franchise relationship, so for a typical franchise relationship, there is no personal jurisdiction over the franchisor for injuries that occur at the franchise location. So that's in the case that bears our name that was recently decided in November of 2024 by the Fort Worth Court of Appeals. There's also the Kumon case from the Houston 14th District Court of Appeals that said the exact same thing, Your Honor. So then really the dispute is, if we agree on that principle, the dispute is over whether this is or is not a garden variety franchise relationship. And we provided ample evidence that it is very much just garden variety, straight lace franchise relationship. We provided the hotel, which is we don't own and we don't operate. We provided them with a limited license to operate under the Hilton name. We provided certain quality standards, and then they run it day to day. We have affidavits from my client, Hilton Franchise Holding, attesting that we do not in any way control the day-to-day operations. We have an affidavit from the hotel owner, Abel, saying that we, Hilton Franchise, has nothing to do with the day-to-day operations. And we have an affidavit from Boykin Prospera, who is the management company, saying that they have sole responsibility for the day-to-day operations and that Hilton Franchise has no responsibility for the day-to-day operations. We don't hire anyone at the hotel. We don't supervise anyone at the hotel. That is simply not our role in a franchise relationship. More specifically to this case, Your Honor, the bartender in question, we did not hire her. We did not train her. We did not supervise her. We did not make any decisions on whether to retain her or not. So plaintiffs try, I think their argument is, well, no, this wasn't a typical franchise relationship, but all the things that they point to are just the hallmarks of what you find in any franchise relationship. They point out that our name was on the hotel, Hilton's name was on the hotel, our logo was on the receipts, employees wore uniforms with the Hilton logo on it, and that we get a revenue share from the hotel. But that's not evidence of a unusual franchise relationship. You would never find a franchise relationship without those characteristics. And then specifically, Your Honor, with going back to the bartender, provided an affidavit confirming that we do not provide any training to the bartenders. There's an acknowledgement that the general manager of the hotel has to check that says this employee, we worked through a third-party training provider to provide this server with the training that's required under Texas law and regulations, but Hilton doesn't administer that training. Hilton doesn't design that training. We have never trained anyone at the hotel involved in alcohol service. So that's sort of the franchise-specific piece, Your Honor. Just talking more general principles. As I've already said, we have no role in the day-to-day operations. The claims do not arise out of the franchise agreement. One of the sort of tools that the Texas Supreme Court has given to try to figure out if the substantial connection test is met is you think about, well, what's going to be the focus of litigation? What's going to be the main issue at trial? What's going to consume most of the litigation's energy? And in this case, Your Honor, the energy is going to be consumed on what Mr. Anderson did, how much alcohol he consumed, how many drugs he consumed, what else he did that night. And then plaintiff's claims are, did this bartender do her job? Was she properly supervised? Should she have been hired? None of those issues have anything to do with Hilton Franchise Holding, Your Honor.
Okay,
and so,
very good. I think thank you. All right, Mr. Nunez. So we've heard from the movement. I must admit the arguments do sound pretty strong. The problem here is that we are not seeing your response in the file. We do see a reply, so we know it's out there. What's going on with your response? Do you know?
I did submit an objection. Do you have the objection? Do you see that to the special appearance?
Let me look and see. Did you not file a response other than the objection?
I did not, Your Honor.
Okay, so what we have is an objection then. Okay, we're looking right now. Let's see here. All right, there's the unopposed motion. No, we don't see it. Okay, so what we have here is we have Hilton Franchise Notice of Oral Hearing. Please take note, that's this one here. Okay, so we have that one. I see the motion for pro hoc. Let's see. I see the reply filed by defendant. I'm looking to see motion. I don't see it. I mean, my briefing attorney is not seeing it either.
Okay.
There's a special appearance and there's a request for issuance of citation, a notice of hearing in the pro hoc motions. So we're not seeing that. Did you get the did you submit it through an e-file,
Yes, Your Honor. And I know that the defendants did receive that objection as well.
So
I
they
think-
may have it, and that's fine. I mean, we're here today, we're here to argue. I'm just a little concerned because I'm not seeing it here. It's, it's possible that there's a problem in the clerk office because that would just go, unlike an order, that would go directly to the clerk, not to the judge. So I am wondering about that a little bit.
I can refile it after this hearing.
Yeah, that might be a good idea if you would refile it. If you would also, since we're considering it right now, if you would please email it to my court so that we can just look at it. It goes to 455.submission, singular, at traviscountytx.gov. Again, 455.submission at traviscountytx.gov. If you send that to us, and we can take a look at the objection. But we can see the interplay between the parties, so we know you all have it because we can see their reply to your objection. We just don't have your objection. So if you'd email that to us as quick, after you finish arguing, obviously, then that would help us, okay? And then let's make sure you get it in the file. All right, Mr. Nunez, we've heard now from Mr. Duboff. Tell me what you have then in response to that argument, sir.
Yes, Your Honor. There are really 3 points that Hilton franchise exercised control over the Hilton Austin Airport Hotel's policies, which are policies and procedures that directly contributed to negligent training and supervision and the over service of alcohol here. That Hilton Franchise Holdings is not just a passive franchisor, but they are actually involved in implementing these procedures such as service and training. Also, that Hilton Franchise is an affiliate of Hilton Worldwide Holdings, and it is plaintiff's position that Hilton Worldwide Holdings did waive specific jurisdiction by filing special exceptions, requesting a trial by jury, among other things. And we believe that because Hilton Franchise Holding is the subsidiary of the corporate parent Hilton Worldwide Holdings, and they act as a single business unit, that jurisdiction should apply to both.
Okay.
And in this case, they receive the same economic benefit as seen in the franchise agreement. So first, I can talk about the Hilton Worldwide. Let me show you the agreement first.
All right, very good.
Just 1 second, Judge.
Okay, see the little green. There you go. Okay.
Okay.
Now we're
So
going.
this is
All right.
the franchise agreement here, Hilton Austin Airport Hotel. It shows their responsibilities, okay, which we're going to get to for the specific jurisdiction. Hilton Franchise Holdings responsibilities are training, reservation service, consultation, marketing, inspections, compliance, assistance. They give out manuals, equipment, and supplies, and the actual hotel's responsibilities are operational and other requirements. So here we have the franchise agreement, Hilton Franchise Holdings, and they state here that they are an affiliate of Hilton Worldwide, which Hilton Worldwide is the entity that we believe waived specific jurisdiction. And here is the affiliate, whether it means any natural person or firm, corporation, partnership, limited liability company, association, trust, or other entity directly or indirectly is controlled by or is under common control with the subject entity. So basically the argument is, since Hilton Worldwide Holding waived jurisdiction, that imputes Hilton Franchise Holdings in this matter, especially because they were both in contract with the Hilton Hotel here, Austin Bergstrom Landhouse Enterprises. So that would be our first argument, Your Honor. The second argument on the specific jurisdiction is we believe that this is more than just a passive franchisor, that they are directly involved in the operation of the Austin Hilton Airport Hotel. I can go back to their standards. These are the standards and system that Hilton Franchise Holdings require the hotel to abide by. And that includes standard specifications, requirements, criteria, policies that are developed and complied by us for use by in connection, design, construction, renovation,
Too
refurbishment.
fast, too fast, too fast, Mr. Nunez.
yeah,
You
but
are
just
on the
started-
record. Good heavens, sir.
I apologize.
Little professionalism goes a long way.
I
So slow
apologize.
down. We just cannot hear you when you go. I can't even understand you, much less my court reporter take a record. So please slow down, sir. All right, thank you. Go
Yes.
ahead.
Okay, so they have to comply with the standards, which include operating and opening, and they have to
Okay.
comply with the system
Mm-hmm.
here. And as we go down in their operation agreement with their responsibilities, they are responsible for training, right? And plaintiff's direct allegations against Hilton Franchise Holdings is the improper training policy and procedures that directly led to Brianna's overservice of alcohol and whether she was supposed to cut him off based on her training.
Let me look. Hang on. Let me look at the training. Let's hold it there for a second so I
Go
can
ahead.
stop so I can read. All right, go ahead.
And the control is further with the inspections and compliance assistance here.
Okay, let me look. So it says that it's saying here, we will administer a quality assurance program for the system that may include conducting pre-opening and periodic inspections of the hotel and guest satisfaction surveys and audit to ensure compliance with the standards, right?
Correct, Your Honor.
Okay, what else?
And these are the responsibilities of the hotel,
Mm-hmm.
that the hotel must operate the hotel using their system, their standards, and that they have provided these standards.
Actually, it says these standards operate the hotel using the system, not their system,
Sorry.
in compliance with this agreement and these standards, not their standards, and in such a manner to provide courteous, uniform, respectable, and high-quality lodging and other services and conveniences to the public. You acknowledge that although we provide the standards, you have the exclusive day-to-day control of the business and operation of the hotel, and we do not in any way possess or exercise such control, which would seem to cut against your argument, Mr. Nunez.
Yes, Your Honor. And plaintiff is alleging that these standards and these procedures and policies that were required that the hotel follow were insufficient and led to this bartender being not qualified to serve as a patron. And we have more evidence here with training from Hilton itself. So Hilton says that they do not train or they have never trained anybody at the hotel. But we see here on the pre-orientation checklist that this is used by Hilton family of brands, that there is a procedure for new hire team members that they are to attend a full day of training orientation workshop.
Okay, hang on, let me look at it. Okay, so this says, the abbreviated orientation checklist is intended to be used by Hilton family of brands, hotels that only conduct full orientation every 14 to 30 days. Please follow these instructions for completion. One checklist is to be completed by the hotel human resources representative and/or department representative for each new hire 2 days after the new team member has started work. The new team member will, don't move it. The new team member will then return within 14 to 30 days for this training to attend a full orientation workshop. The team member should be instructed to review the handouts and be ready to discuss during the full orientation. The completed checklist should be signed and stored in the Human Resources Department. Depending on the size of the hotel, this abbreviated orientation should take between 30 and 60 minutes to complete. And it's signed then by Miss Brianna Villejo, who I assume was the bartender. Is that right, Mr. Nunez?
Yes, Your Honor.
All right, very good. Okay, go ahead.
Yes, and so I think that this plaintiff suggests that this is an essence of the training, that they have to go to a full orientation and discuss the drug and alcohol policy. And this was designed by Hilton. Moreover,
where does it say that about the drug and alcohol policy? Oh, right there, standards and policies, discuss standards of conduct policy, and then drug and alcohol policy. Harass, but see, the drug and alcohol policy, I mean, I don't know, that just sounds like to me that it's dealing a little bit with more HR matters. And the only reason I say that is because around it is attendance policy, which pertains to the worker, not hotel attendance policy, and then harassment-free workplace, and then diversity mission statement. That just sounds like it's more to do with the policies at the hotel rather than the drug and alcohol policy that relates to the guest. You know what I'm saying? It doesn't make, what you're saying doesn't make any sense within that box to me. So, yeah, you still may be right. I'm just saying, look at the things around it. Those standards and policies are pertaining to employees. They're not guests. Otherwise, it wouldn't say attendance policy. Okay. What next?
The new hires go under a Hilton University. Let me try to find it. Where there is training on policies and procedures.
Uh-huh.
It's somewhere around here.
I see Hilton University. I see it.
This
Okay.
is ran by Hilton Worldwide Holdings.
Right. Okay, and so you're saying here the health and safety general manager acknowledgement, is that what you're talking about?
Correct, Your Honor.
Preventing human trafficking, that does sound like it relates to guest. ADA service animals does sound like it relates to guest. And then cybersecurity, not so much. Okay, so we've got that. And then we've got the alcohol awareness and general manager acknowledgement from 2019. And then health and safety acknowledgement at food safety and sanitation, breakfast at Hilton, ADA effective communication, service animals, food and beverage. Yeah, that does sound like it relates to guest. All right, keep going.
And this continues. We saw 2019, this is 20. I believe it happens every single year.
Okay.
And so really that's what I have for now. Here's the Hilton Hotels new hire orientation by Hilton that they were required to do.
Mm-hmm.
That they were required to undergo alcohol training as well.
Oh, okay, responsible alcohol service. Now that does sound like it relates to the guest. Okay. But scroll back up. Is that security awareness? What's under that? Slips, trips, and falls. Okay, well, that does sound like that's guest related. Okay.
And so really, Your Honor, that's what I have here, that Hilton franchise exercised substantial control over the Texas hotel where the incident occurred, such as setting the safety policies, training standards, operational requirements, and its connection to Texas and serving patrons in Texas is not just incidental, but rather integral to this exact case. So they require the franchisee to adhere to brand-wide policies related to security, guest safety, maintenance, and incident reporting. As you saw, they also did compliance audits to make sure that they were abiding by the Hilton standard. They also actively market, as Your Honor probably knows, to Texas residents. And they also have that, again, contractual and supervisory role by those regular inspections and compliance mandates. So what plaintiff is trying to say is that there is specific jurisdiction here, and the relationship between Hilton Franchise Holding and Austin Airport Hotel will be a substantial part of this case, because we need to find out who is running, basically the Hilton franchise is running the hotel and has the hotel operating under a certain standard, and that's what led to the overservice of alcohol. And so that is really our argument here, that it is not just a regular franchisor, that is a little bit more and sufficient for specific jurisdiction.
All right. Thank you, Mr. Nunez. All right, Mr. Duboff, what do you have by way of reply, sir?
Thank you, Your Honor. I guess I'll just pick up right where Mr. Nunez stopped, Your Honor. He said, that their allegation is that Hilton Franchise Holding LLC, I think he said, is running the hotel. And that's an argument from counsel, and that's fine, but there's no evidence of that. The only evidence that's before the court is an affidavit from Hilton Franchise Holding, an affidavit from Abel, who owns the hotel, and an affidavit from Boykin Prospera, sworn affidavits that are real evidence. And every single one of those says Hilton Franchise Holding has no control over the day-to-day operations. The hotel is owned by Abel, and it delegates its operation of the hotel to Boykin Prospera. So that's the actual evidence that's been presented here, and there's no evidence to refute that. Mr. Nunez showed a lot of documents. If we had focused on the base numbers of those documents, Your Honor, those are not documents that my client produced, because we don't have those. Those are documents that are maintained by the franchisee, because they are the ones who administer the training, they provide the training, they run any orientation. The only evidence here is that Hilton has nothing to do with those things. We, in terms of that alcohol awareness, there was that training roster, and we provided an affidavit in our replies. This is the affidavit of Blair Bojwani. I'm sure I butchered the last name, which says this person who's a VP, Vice President for Learning at Hilton, and says in this sworn affidavit that no Hilton entity provides or conducts alcohol awareness training. The reason for that form is it's a checkbox. It's a form that the general manager checks simply to certify that an employee who is required by state law to get training has received the training they need to get. In the same way that general managers check a box to confirm to Hilton that our fire suppression system has been inspected as required by state law. So I think, through all of Mr. Nunez's argument, Your Honor, we still come back to the same point, which is that we agree that the relevant question for the court, the relevant standard here is this a typical garden variety franchise relationship? And if it is, then there's no personal jurisdiction for the causes of action here. And the things that I heard Mr. Nunez talk about were things like we implement standards and procedures. Well, of course we do. You literally can't have a franchise agreement if you don't, and you can't actually maintain a trademark if you just let anyone use it and don't maintain the quality of the trademark. He talked about these different requirements that we have. He talked about the inspections. We cite, Your Honor, in our reply, and it's a case from the Northern District of Georgia, I believe. But it's a Ramada case. And in that case, the court talks about what a typical franchise agreement includes. And it includes providing trademark and brand signage, providing equipment, supplies, the payment of royalty fees and taxes, setting hours and holidays, determining acceptance of credit cards and storage of consumer data, requiring job training is a typical responsibility of a franchisor, providing training tools and materials, and retaining the right to inspect the facility. So everything that Mr. Nunez spoke about are all not just hallmarks, they're just inescapable. You can't have a franchise, they're definitional to what a franchise relationship is. And the only thing that's on the record saying other than that is just Mr. Nunez's argument that all of these things are unusual and that all of these people in the affidavits are lying, and really it's Hilton Franchise that controls the day-to-day operation. So that's just not how it works. Under Rule 120A, we have evidence that says those allegations are not true. There's no evidence rebutting them, and so the special appearance we would respectfully submit should be granted.
All right, here's what I'm going to do. I need to, before I rule on this, I would like to personally review Mr. Nunez's objection to the special appearance, because we don't have that right now. And I feel, I would feel remiss to not review that before issuing a ruling in this case. So Mr. Nunez, would you please email that to us, and then we will take this under advisement and get you all a ruling as quickly as we can. Mr. Frankel, if you would please send Mr. Duboff's pro hoc vice motion in order to this court. We'll let Judge Mangrum know right now that we will be ruling on that today. And then let's go from there. Ms. Swilley, do you have anything to add to this argument?
I do not, Judge. I don't have anything on file, but I can represent to you as counsel for Boykin Prospera that we do operate the hotel. We have an agreement with Abel, the owner of the premises, to operate the hotel and run the day-to-day operations, which includes hiring and training.
Right. Okay. Thank you. That's helpful to know. All right. Very good. Does anyone else have anything else to say?
One more thing I'd like to add, Your Honor.
Yes, Mr. Nunez.
Hilton Worldwide Holding is still a party to this suit. So I would like this court to take that into consideration when reviewing the waiver argument.
Hilton Worldwide Holding. I'm looking here. I see Austin Bell. I see Austin Bergstrom Landhost. I see Boykin Management. I see Boykin Prospera. I see Hilton Franchise Holding, and I see Brianna Celeste Vallejo. Let me look on the next page, because it might be on the next page.
Your Honor, they are not on the active pleading, but they are still a party to this suit.
Your Honor, if I could be heard on that, this is
yes, thank you.
I'm disappointed that Mr. Nunez would try to make that argument. As background, Hilton, it's unfortunate because it violates an agreement that we had. There's a reason why Hilton Worldwide is not on the pleading. It's because Mr. Nunez and I had an agreement where he said he would dismiss them from the case. He just didn't file the right paperwork to get that done. As background, and I don't want to skyline anyone, Your Honor, but filings were made on behalf. I've never represented Hilton Worldwide Holdings Inc., but filings were made on behalf of that entity that were not authorized by the client.
Okay.
So when I was brought in, one of the options was we could move to strike the answer that was filed because it was filed by an attorney without authorization. But I also knew that while we don't think there's any personal jurisdiction here, Mr. Nunez at that time had not even sued Hilton Franchise Holding, which is the franchisor. And so I reached out to Mr. Nunez and I said, here are options, I think. I can move to strike the answer of Hilton Worldwide, but at the end of the day, they're not even the franchisor. That's not even the right entity for you to really think about suing if you have a claim against any Hilton entity. And so what I said is I can, if you agree, I can provide you the name of the franchisor. I provided him with the franchise agreement showing who the franchisor was. And this is all in email. And in the part of that agreement was that he would dismiss Hilton Worldwide Holdings Inc. from the case, and I would agree to accept service on behalf of Hilton Franchise Holdings, that he wouldn't have to go through the process of serving that entity. So that was our agreement, Mr. Nunez, and I'm not sure on what grounds you would possibly now, just because you didn't file the right paperwork, why you would.
The comments need to come to the judge, not to each other. And honestly, folks, I don't care. You need to get this worked out. It's not a good look. It's not a good look to zoom into Travis County Court with a disagreement. So I want y'all to take a breath, maybe cool off a little bit, and talk this one out. All right. We're going to have to, Mr. Nunez, that's not a good look, sir. This is not what you want. And I know you've got a different view on it, and you all cannot sit on a Zoom call. It's like you're fighting in open court. We just cannot have it. So I want both of y'all to cool off and have a good think, and then talk to each other and get this worked out. All right. With that, I'm going to take this case under advisement. I do need to see Mr. Nunez's objection before I rule on this. And Mr. Frankel, please make sure that you send me in the submission inbox the Mr. Duboff's ProHawk so I can get that order signed today, sir. Okay?
Yes, Your
Thank
Honor.
you, Your Honor.
Thank you,
All right,
Ron.
very good. You all may be excused. Thank you.
Thank you, Your Honor.
Thank you. All right, I think we might be getting to the end of the day here. Miss Dewitt, are you okay to go on, or do you need a little break, ma'am?
I am good, Judge. I'm good. Yep.
Okay, very good.
It doesn't
All right.
look like we have anybody else on.
Oh, interesting.
Anyone
I see
here?
that.
No one
GM
else.
24001816? No.
Mm-mm.
All